Banking Law Notes by M.G. Law. Today we will do Liability of Surety, page number 14. Liability of Surety, or you can say guarantor. The liability or responsibility, accountability of surety or guarantor. Okay. In contract of guarantee, under Indian Contract Act section 126, there are three parties. One is creditor, who gives the money or the loan. Second is debtor or borrower, who takes the money or debt or loan. And the third one is a surety, or you can say guarantor, who gives the assurance or promise to the creditor. The surety makes promise to creditor that on debtor's default I will pay. If the debtor is unable to pay, or if he is not paying the money or the value back to the creditor, then the surety or guarantor will pay the money. There are three essentials. That first one is there should be a consideration that the debtor or the borrower should take some money or value for which he is paying back. If there is nothing taken by the debtor or valuer, then there is no guarantee. Second one is disclose all material facts to the surety. All the main facts, all the main points, important points of the contract should be disclosed to surety. He should know all the facts. You cannot hide any fact from the surety. Third one is that contract can be oral or written, in both types. Nature of liability of the surety. What's the nature of the accountability of surety? It is coextensive. It means it is having the same extent as that of debtor. The range or degree of liability of debtor, that degree or range or extent, that surety will also have that much extent of liability. Surety may impose limits to liability in the contract. If the surety wants to limit its liability, then he should impose that limit in the contract itself. The surety's liability is secondary. The primary liability is of debtor. First, the debtor has to pay. If the debtor is unable to pay, then only the surety will pay. It means it has secondary liability. Kinds of guarantee, or you may say kinds of liability. One is specific guarantee. A specific guarantee is for any specific or particular transaction. Second one is continuing guarantee. It is for a series of transactions, one after another. For all the transactions, the surety or guarantor will be liable. Revocation or cancellation or removal of guarantee. How the guarantee can be removed? The surety may give notice to creditor that for future transaction he will not be liable. Or on the death of surety, when the surety dies, the liability for all future transactions will be removed. But for the past transactions which have already taken place before the death of surety, his legal representatives will be responsible. Discharge of surety. How the surety is fulfilled? The surety will be fulfilled. The surety will get discharged if the debtor makes the payment. Okay. Second one is The creditor himself release the debtor and say that now you are released, or the creditor makes some omission due to which the debtor gets discharged. Then the surety will also get discharged. Or there are change in terms of the contract without surety's guarantee consent. It means that the creditor and the debtor changes the contents or terms of the contract without taking the consent of surety. Then the surety will not have any liability. Or the creditor does any act inconsistent with surety's rights. If the creditor do anything which is in contradiction to the surety's right, then also the surety will get discharged. So summary. Now summary of the chapter. First, we saw contract of guarantee under Indian Contract Act, that there are three parties: creditor, debtor, and a surety or guarantor. According to the contract of guarantee, surety promises the creditor that if debtor defaults, then he will pay. Okay, there were three essentials. There should be some consideration in the transaction. Second one was all material facts must be disclosed to the surety. Third was the contract can be oral or written. Okay. Next thing was the nature of liability of surety. What was the nature of liability? Okay. First was coextensive. It was having the same extent as that of debtor's liability, although the surety may impose limits which he should mention in the contract. And second one was that the surety was having secondary liability. The primary liability was of debtor. Next was kind of guarantees. One was a specific guarantee which was concerned with the specific transaction. Another one was continuing guarantee which was for a series of transactions. Okay, now how the guarantee can be revoked. Revocation of guarantee. One was when the surety gives notice to creditor that for all future transactions he will not be liable. Second was on his death. Okay, how the surety get discharged or relieved. One was if the debtor makes payment. Second, the creditor release the debtor or makes omission by which the debtor gets released. Third was the in the terms of the contract gets changed but without taking the surety's consent. And the next one was the creditor does any act inconsistent with surety's right. Okay, so this was the summary of this chapter. If you are interested in getting the PDF of this notes, you can get it from the comment section or from the description box. Next is payment in due course and paying current collecting banker, which we will do in next video.